Lesson 13. General Meetings Company Law, India. 1. Corporate Meetings and Collective Decision Making. 1. Decisions in a company are taken collectively in general meetings, ensuring member participation. 2. Types of meetings. Annual General Meeting AGM. Extraordinary General Meeting EGM. Class Meetings. Meetings of debenture holders creditors. 3. Importance. Legal compliance, protection of minority rights, passing resolutions. 4. Case law. Lalchand Jain vs. CIT 1962. Collective decisions must strictly follow statutory procedures to be valid. 5. Exam tip. Remember, collective decision equals validity depends on procedure. 2. Annual General Meeting AGM. 1. AGM must be held every year by all public companies except OPC and small company. 2. Time frame. Within 6 months from end of financial year. Total gap from last AGM should not exceed 15 months. 3. Business transacted. Approval of financial statements. Dividend declaration. Appointment reappointment of directors. Appointment reappointment of auditors. 4. Explanatory statement. Required for special business under Sec 100(2)(a). 5. Case law. K. Verma vs. Union of India 1978. Holding AGM beyond statutory period is irregular. Attracts penalty. 6. Penalty. Non-compliance can lead to fines on company and officers. Sec 99, 102. 3. Extension of validity period of AGM. 1. Companies may apply to ROC for extension beyond statutory time. 2. Time frame. Maximum extension is granted by ROC. 3. Process. File request with justification. ROC may approve. 4. Exam tip. Always link extension allowed by ROC with AGM compliance question. 4. Day, time, and place for holding AGM. 1. Must be held during business hours 9 a.m. 6 p.m. 2. Place. Registered office or other location allowed by articles. 3. Notice. Must specify day, date, time, venue. 4. Exam tip. Always include this when drafting notice. 5. Business to be transacted at AGM Sec 100(2)(a). 1. Ordinary business. Approve financials. Dividend declaration. Appointment reappointment of directors and auditors. 2. Special business. Alteration of articles. Issue of shares. Approval of related party transactions. 3. Explanatory statement. Must explain purpose of special business. 4. Sample resolution. Ordinary. Resolved that the audited financial statements of the company for the year ended the 31st of March 2025 be and are hereby approved. 5. Exam tip. Be able to differentiate ordinary versus special business clearly. 6. Convening of a valid general meeting. 1. Must comply with proper notice, adequate quorum, proper agenda, appointed chairman. 2. Penalties. Non-compliance attracts fines under Sec 99, 102. 3. Process. Meeting convened by board. Notice sent to all entitled persons. 4. Exam tip. Always mention quorum, notice, and chairman when asked about validity. 7. Extraordinary General Meeting EGM. 1. Held for urgent or special business that cannot wait till AGM. 2. Requisition. Members holding 10% voting power can call EGM Sec 100. 3. Time frame. Notice 21 clear days, similar to AGM. 4. Case law. Raghunath vs. Union of India. EGM requisition by members must be complied with by board. 5. Exam tip. Differentiate AGM and EGM in terms of frequency, purpose, and statutory requirement. 8. Class meetings. 1. Meeting of a specific class of shareholders, e.g. preference shares. 2. Required to approve matters affecting only that class. 3. Quorum and notice. Same principles as AGM EGM, but restricted to class members. 9. Meetings of debenture holders, creditors, etc. 1. Purpose. Approve modifications in rights, schemes of arrangement, or debt restructuring. 2. Notice and quorum. Governed by Articles Trust Deed or Sec 178 for debenture holders. 3. Case law. IDBI Limited vs. T. Venkat Rao 1999. Resolutions of debenture holders must comply with procedure for validity. 10. Adjourned meeting. 1. Adjourned due to lack of quorum, incomplete discussion, other reasons. 2. Notice. Not required if adjourned date announced in original meeting. 3. Resolutions. Valid if quorum present at adjourned meeting. 11. Procedure for holding adjourned meeting. 1. Follow same procedure as original meeting. 2. If quorum present, business can be transacted without fresh notice. 12. Resolution passed at adjourned meetings. 1. Valid only if quorum is present. 2. Voting and recording of minutes is in normal meeting. 13. Types of resolutions. 1. Ordinary resolution. Greater than 50% majority. 2. Special resolution. 75% majority. 3. Resolution requiring special notice. Sec 115. Removal of directors auditors. 4. Case law. KP. Varghese vs. Ito 1981. Correct counting of votes is mandatory. 14. Ordinary and special resolutions. 1. Ordinary. Routine business. 2. Special. Matters requiring higher consensus 75%. 3. Sample special resolution. Resolved that the articles of association of the company be altered as per the attached draft. 15. Resolutions requiring special notice. 1. Includes removal of directors or auditors before expiry of tenure. 2. Notice of such resolution must be sent to company 14 days before meeting. 16. Process of passing resolutions. 1. Methods. Show of hands. Electronic voting, e-voting. Postal ballot. 2. E-voting. Mandatory for listed companies and companies with greater than 1,000 members. 17. Notice of meeting. 1. Must be in writing, physical or electronic. 2. Length. 21 clear days Sec 102. 3. Contents. Date, time, venue, agenda, proxy form, explanatory statement. 18. Length of notice of meeting. Minimum 21 clear days, excluding dispatch and meeting day. 19. Shorter notice. 1. Only allowed with 95% members consent Sec 101. 2. Must include same details as normal notice. 20. Contents of notice. Must include agenda, day, date, time, venue, proxy details, explanatory statement, voting instructions. 21. Place of meeting. Registered office or permitted place by articles. 22. Day of meeting. Must be business day (mon, sat) within statutory period. 23. Time of meeting. During business hours 9 a.m. 6 p.m. 24. Agenda. Must clearly separate ordinary and special business. Agenda equals meeting plan plus items for decision making, and special business needs explanatory statements. 25. Proxy clause with reasonable prominence. 1. Members may appoint proxy using Form MGT 11. 2. Must submit 48 hours before meeting. 26. Persons entitled to receive notice. Members, directors, auditors. Certain officials as per SS2. 27. Notice to directors, auditors and other specified persons. Directors, auditors, key managerial personnel must be notified even if they are not members. 28. Statement to be annexed to notice. Explanatory statement. Explains purpose and effect of special business. Ensures members make informed decision. 29. Quorum for meetings. 1. Private company. 2 members. 2. Public company less than 1,000 members. 5 members. 3. Public company 1,001. 5,000 members. 15 members. 4. Public company greater than 5,000 members. 30 members. 5. Sec 103. Quorum required at start. Failure right pointing arrow adjournment. 30. Chairman of meetings. Presides, ensures orderly conduct, agenda compliance, resolutions passed correctly. 31. Proxies. 1. Allow members to appoint another person to attend and vote. 2. Form MGT 11, 48 hours before meeting. 32. Voting. 1. Show of hands. 1 vote per member. 2. E-voting. Secure electronic platform. Mandatory for listed companies and greater than 1,000 members. 3. Postal ballot. For special ordinary business Sec 110. 33. Voting by show of hands. Each member has 1 vote. Simple majority decides. 34. Voting through electronic means. Secure e-platform ensures transparency, record keeping. 35. Procedure of e-voting. 1. Members get login credentials. 2. Votes cast electronically. 3. Results published, recorded in minutes. 36. Postal ballot. 1. Sec 110. Members vote by post email. 2. Used for special business or small members. 37. Circulation of members resolution. 1. Members holding 1% voting power may circulate resolution Sec 105. 2. Resolution included in next meeting agenda. 38. Maintenance of minutes of meetings. 1. Recorded within 30 days. 2. Preserved 8 years. 3. In mergers amalgamations, minutes form part of statutory record. 39. Secretarial Standard 2 on general meetings. 1. Issued by ICSI. 2. Covers notice, agenda, quorum, proxies, voting, minutes. 3. Compliance is mandatory. 40. Preservation of minutes in case of scheme of merger and amalgamation. Minutes must be preserved as part of statutory record even after merger amalgamation. 41. Report on annual general meeting. 1. Company must file MGT 7 with ROC. 2. Reports include attendance, resolutions passed, voting results. 42. Duties of company secretaries before, during, and after general meeting. 1. Before. Draft notices, agenda, sent to members. 2. During. Ensure quorum, conduct meeting per SS2. 3. After. Prepare and sign minutes, file necessary returns. 43. Virtual meetings. Technological advancement in conduct of general meetings. 1. Allowed by law for companies using video conferencing other electronic means. 2. E-voting and minutes still required. 44. Drafting of notice and minutes of AGM and EGM. 1. Notice must clearly state agenda, special business, proxy, voting methods, time, date, place. 2. Minutes must include summary of proceedings, resolutions, dissenting opinions. Key case laws. 1. Lalchand Jain vs. CIT 1962. Collective decisions must follow procedure. 2. K. Verma vs. Union of India 1978. AGM held beyond statutory time is irregular. 3. KP. Varghese vs. Ito 1981. Voting counting must be accurate. 4. IDBI Limited vs. T. Venkat Rao 1999. Debenture holder resolutions require procedure compliance. Exam tips. 1. Always mention quorum, notice period, venue, and time for validity. 2. Differentiate AGM and EGM clearly. 3. No types of resolutions with majority percentages. 4. Proxy, e-voting, postal ballot. Link to sections 105, 110. 5. Short notes. SS2 compliance, duties of company secretary. 6. Sample resolutions may be asked. No ordinary versus special. 7. Penalties and fines. Sec 99, 102, 118. 8. Virtual meeting rules. Increasingly important. 9. Always link case law to procedure or validity. Lesson 14. Directors Company Law, India. 1. DIN requirement. 1. DIN equals director identification number, mandatory for all directors Sec 154. 2. 1 director equals 1 DIN throughout lifetime. 3. Required before appointment to any company. 4. Penalty. Appointment without DIN attracts 100,000 rupees fine Sec 167. 5. Exam tip. DIN is unique and permanent. Link to KYC-DIR 3 compliance. 2. Documents required for obtaining DIN. 1. Identity proof. PAN card, passport, driving license. 2. Address proof. Passport, voter ID, Aadhaar, driving license. 3. Recent passport size photograph. 4. Consent to act as director form DIR 2. 5. Exam tip. Know both ID and address documents. PAN is mandatory. 3. Procedure for generation of DIN. 1. Apply online via MCA portal using DIR 3 form. 2. Upload proofs and photograph. 3. DIN generated instantly if documents correct. Else MCA may seek clarification. 4. Exam tip. Remember DIR 3 is the key form. 4. Cancellation surrender deactivation of DIN. 1. Cancellation. For duplicate or wrongful DIN. 2. Surrender. Voluntary surrender possible. 3. Deactivation. Non-compliance with KYC-DIR 3 KYC. 4. Penalty. Sec 164,167. Director not eligible if DIN cancelled. 5. Exam tip. Differentiate cancellation versus deactivation versus surrender. 5. Impact of non-compliance of DIR 3 KYC-DIR 3 KYC web. 1. Mandatory annual KYC update. 2. Non-compliance right pointing arrow DIN deactivated. 3. Penalty. Director cannot hold directorship in any company. 4. Exam tip. Annual KYC is crucial. Link to MCA portal. 6. General provisions regarding DIN. 1. DIN unique for each director, lifelong. 2. No company can appoint director without valid DIN. 3. Existing DIN holders must update KYC annually. 4. Case law. Vishal vs. MCA 2015. Appointment invalid if DIN deactivated. 5. Exam tip. DIN compliance equals appointment validity. 7. Types of directors. 1. Executive director whole time. Involved in management. 2. Non-executive director. Not involved in daily affairs. 3. Independent director ID. Sec 149-6. Listed companies and certain unlisted companies. 4. Nominee director. Appointed by financial institutions or shareholders. 5. Additional alternate first directors. Specific provisions under Sec 161. 8. Definition of an independent director. 1. Sec 149-6. Not holding pecuniary relationship or material interest with company. 2. Should be free from conflicts, not part of management. 3. Exam tip. ID protects shareholder and minority interest. Remember listed company requirement. 9. Remuneration of an independent director. 1. Fixed sitting fee for meetings. 2. Can receive profit-linked commission max 1% of net profits for whole board. 3. No stock options for listed IDs as per Sec 197. 4. Exam tip. No limits of remuneration and profit-linked commission. 10. Term of an independent director. 1. Initial term. 5 years Sec 149. 2. Reappointment. Up to 2 consecutive terms allowed total 10 years. 3. Cooling off period. 3 years after 2 terms before reappointment. 4. Exam tip. ID term differs from ordinary director. Remember 5+5 rule with cooling period. 11. Appointment of directors in casual vacancy. 1. Board can appoint directors to fill casual vacancy until next AGM. 2. Requires members' approval at next AGM. 3. Form. DIR 12 filed with ROC within 30 days. 12. Appointment, reappointment, disqualifications, vacation of office, retirement, resignation, and removal of directors. 1. Appointment. By members at AGM or by Board Sec 152. 2. Reappointment. Retiring directors eligible if not disqualified. 3. Disqualification. Sec 164. Undischarged insolvent, convicted, defaulting company. 4. Vacation. Non-attendance greater than 12 months, insolvency, disqualification. 5. Resignation. File DIR 11, effective upon receipt. 6. Removal. Sec 169. Shareholders can remove by ordinary resolution. 7. Exam tip. Remember all routes for appointment and removal. 13. Appointment of first director. 1. Specified in Articles of Association. 2. Must obtain DIN before appointment. 3. Form DIR 12 filed with ROC within 30 days. 14. Appointment of directors by board. 1. Sec 161. Board can appoint additional directors or fill casual vacancy. 2. Temporary appointment until AGM approval. 15. Procedure for appointment of additional director. 1. Board may appoint extra directors within authorized limit. 2. Must be approved in next AGM. 3. Form DIR 12 filed with ROC. 16. Procedure for appointing directors in casual vacancy. 1. Board appoints temporarily. 2. Member approval required at next AGM. 17. Procedure for appointment of an alternate director. 1. Alternate director appointed when original director absent greater than 3 months abroad. 2. Written consent required. Board passes resolution. 3. Form DIR 12 filed. 18. Appointment of directors by tribunal. 1. NCLT can appoint directors if company fails to appoint as per articles. 2. Power under Sec 242, 244. 19. Appointment of director by system of proportional representation. 1. Optional for public company. 2. Shareholders vote proportionally, minority representation ensured. 20. Appointment of nominee directors. 1. Appointed by financial institutions, shareholders, or lenders. 2. Must consent in writing. 21. Procedure for appointment of directors to be elected by small shareholders. 1. Shareholders holding less than 10% voting rights may elect small shareholder director. 2. Sec 151. Ensures representation. 22. Appointment of directors by members at general meeting. 1. Ordinary or special resolutions passed in AGM-EGM. 2. Form DIR 12 filed within 30 days. 23. Procedure for reappointment of the retiring director at AGM. 1. Retiring directors eligible for reappointment unless disqualified. 2. Ordinary resolution passed in AGM. 3. Exam tip. Retirement equals rotation, but IDs may differ. 24. Appointment of independent directors. 1. Sec 149. IDs appointed by members resolution. 2. Eligibility criteria. Expertise, integrity, independence from management. 3. IDs listed in Databank ICSI portal. 25. Appointment and removal requirements for IDs in case of listed companies. 1. Listed companies must appoint 1/3 of board as IDs. 2. Removal. Only by special resolution after notifying SEBI ROC. 26. Appointment of independent director on unlisted material subsidiary. 1. Mandatory for unlisted material subsidiaries of listed parent company. 2. Protects minority shareholders of parent company. 27. Reappointment of independent directors. 1. Max 2 consecutive terms 5 + 5 years. 2. Cooling off period 3 years before next appointment. 28. Selection of independent directors. 1. Based on skills, experience, integrity. 2. Nominations recommended by nomination committee listed companies. 29. Enrollment in databank of independent directors. 1. IDs must register in ICSI databank. 2. Online portal maintains eligibility and track record. 30. Disqualifications for appointment of director. 1. Sec 164. Undischarged insolvent. Convicted for fraud offense. Disqualified by court tribunal. Defaulting on company deposits loan repayment 2. Penalty. Director becomes ineligible. 31. Vacation of office. 1. Non-attendance greater than 12 months, disqualification, insolvency. 2. Sec 167. Automatically vacates office. 3. Form DIR 12 filed with ROC. 32. Resignation of directors. 1. Submit DIR 11 to company and ROC. 2. Effective date equals receipt by company. 33. Removal of directors. 1. Shareholders can remove via ordinary resolution Sec 169. 2. Tribunal may remove in case of mismanagement, fraud, or incapacity. 34. Loans to directors. 1. Sec 185. Loans advances to directors restricted. 2. Exceptions. For subsidiary companies or approval by special resolution. 35. Disclosures by a director of his interest. 1. Sec 184. Declare interest in contracts companies. 2. Filed with board and entered in register. 36. Duties of directors. 1. Act in good faith, for company's benefit Sec 166. 2. Avoid conflicts of interest. 3. Exercise due diligence. 4. Comply with articles and law. 37. Register of directors and key managerial personnel and their shareholding. 1. Maintain Form MGT7 DIR 12. 2. Updated within 30 days of change. 38. Specimen resolution. Appointment of director. Resolved that Mr. X, DINO 1234567, be and is hereby appointed as director of the company with effect from date, and the company secretary is authorized to file necessary forms with ROC. Key case laws. 1. Vishal vs. MCA 2015. Appointment invalid if DIN deactivated. 2. K. Verma vs. Union of India 1978. Appointment procedure critical. 3. RK. Agarwal vs. SEBI 2010. ID duties and disclosure compliance mandatory. Exam tips. 1. DIN and KYC compliance equals must remember. 2. Differentiate types of directors and their appointment methods. 3. Independent directors equals term, reappointment, data bank. 4. Forms DIR 3, DIR 11, DIR 12 are critical. 5. Vacations, resignations, removals equals separate procedures. 6. Loans, disclosures, duties equals often case-based questions. 7. Sample resolutions may be asked for AGM board appointments. Lesson 15. Board composition and powers of the Board Company Law, India. 1. Board composition. 1. Sec 149. Every company must have board of directors. 2. Public company must have min 3 directors private. 2. Max as per articles of association. 3. Board may include executive, non-executive, independent, nominee directors. 4. Directors appointed as per Sec 152 in articles. 5. Case law. Vishal vs. MCA 2015. Appointment invalid if DIN KYC non-compliant. 6. Exam tip. No minimum, maximum directors, and different types. 2. Board composition in listed entities. 1. Listed companies must have 1/3 independent directors. 2. ID eligibility. Sec 149 6. Integrity, expertise, independence. 3. Listed company must follow SEBI LODR regulations. 4. Women director. Sec 149(1). Mandatory for listed public companies. 3. Number of directorships. 1. Maximum 20 directorships in public companies. 2. Max 10 listed companies directorships Sec 165. 3. Excess directorship equals disqualification. 4. Exam tip. Always link Sec 165 with compliance check. 4. Board committees. 1. Committees assist board in efficient functioning. 2. Common committees. Audit, nomination and remuneration, stakeholders relationship, risk management, CSR. 3. Committees must comply with composition and quorum rules. 5. Functions of board committee. 1. Perform delegated powers of board. 2. Make recommendations for financial, HR, compliance matters. 3. Maintain minutes and reports. 6. Powers of the board to form a committee. 1. Board may form committees under Sec 177 and 178. 2. Delegation. Subject to articles and law. 3. Cannot delegate core powers such as approval of financial statements. 7. Mandatory board committees. 1. Sec 177. Audit committee. 2. Sec 178. Nomination and remuneration committee and stakeholders relationship committee. 3. Listed companies must have all 3. 8. Audit committee. 1. Mandatory for public companies with paid up capital greater than 10 crores, turnover greater than 100 crores, or borrowings greater than 50 crores. 2. Functions. Oversight of financial reporting, internal audit, risk management, RPT approvals. 9. Constitution of Audit Committee. 1. Min 3 directors, all financially literate. Majority IDs for listed companies. 2. Chairman. Independent director, mandatory in listed companies. 10. Composition of the Audit Committee. 1. Sec 177. Majority of members should be independent directors in listed companies. 2. Members appointment. Board resolution. 11. Functions role of Audit Committee. 1. Oversee financial reporting and disclosure. 2. Review internal audit and compliance. 3. Approve related party transactions. 4. Recommend appointment removal of auditors. 5. Case law. Tata Steel vs. SEBI. Audit Committee role crucial in preventing RPT misuse. 12. Omnibus approval of related party transactions. 1. Audit Committee may grant omnibus approval for repetitive RPTs. 2. Limits. RPT must be is less than or equal to 1 year, is less than or equal to material thresholds per SEBI Companies Act. 13. Disclosure in Board's report. 1. Sec 134. Audit Committee reports in Board's report. 2. RPT, material transactions, financial risks must be disclosed. 14. Vigil mechanism. 1. Sec 177(9). Whistleblower mechanism for directors' employees. 2. Company to investigate complaints of fraud mismanagement. 3. Mandatory for listed companies and prescribed public companies. 15. Nomination and Remuneration Committee. 1. Sec 178. For appointment, reappointment, remuneration, performance evaluation of directors. 2. Helps ensure transparent selection and reward process. 16. Constitution of Nomination and Remuneration Committee. 1. Listed. Min 3 directors. All IDs. 2. Private. May vary but preferably majority IDs. 17. Composition of Nomination and Remuneration Committee. 1. Chairman. Independent director. 2. Majority. Independent directors in listed companies. 18. Functions of Nomination and Remuneration Committee. 1. Recommend appointment reappointment of directors KMP. 2. Recommend remuneration structure. 3. Performance evaluation of board members. 4. Ensure succession planning. 19. Stakeholders Relationship Committee. 1. Sec 178. For handling grievances of shareholders, debenture holders. 2. Monitors transfer of shares, debentures, complaints. 20. Constitution of Stakeholders Relationship Committee. 1. Chairman. Non-executive director. 2. Listed. Min 3 directors. Majority may be non-executive. 21. Composition of Stakeholders Relationship Committee. Min 3 directors. Suitable expertise in finance, legal, administration. 22. Functions of Stakeholders Relationship Committee. 1. Resolve shareholder grievances. 2. Oversee share transfer, DAMOT, redressal. 3. Ensure timely disclosure to board. 23. Penalty for contravention of Section 177 and 178. 1. Non-compliance. Company and officers 100,000 rupees. 500,000 rupees fine. 2. Exam tip. Mention penalties in committee-related questions. 24. Risk Management Committee. 1. Mandatory for top 500 listed companies by market cap. 2. Purpose. Identify and mitigate business, financial, operational risks. 25. Constitution of Risk Management Committee. 1. Board appoints members. IDs may be included. 2. Chairman may be executive or non-executive director. 26. Composition of Risk Management Committee. Depends on board resolution. Experts in risk, finance, operations. 27. Meetings quorum. 1. Quorum equals 2 members or 1/3 of members. 2. Must meet periodically at least twice a year for audit. 28. Functions role of Risk Management Committee. 1. Formulate risk policy. 2. Monitor financial, operational, strategic risks. 3. Suggest mitigation strategies. 29. Powers of Risk Management Committee. 1. Recommend policies, review risks, suggest board actions. 2. Cannot approve financials or related party transactions. 30. Corporate Social Responsibility Committee. 1. Sec 135. Mandatory for companies. Net worth is greater than or equal to 500 CR, turnover is greater than or equal to 1000 CR, or net profit is greater than or equal to 5 crossing. 2. Purpose. Oversee CSR activities and expenditure. 31. Functions of CSR committee. 1. Recommend CSR policy. 2. Approve CSR expenditure. 3. Monitor CSR project implementation. 4. Report to board and financial statements. 32. Other board committees. 1. Share allotment committee. 2. Investment committee. 3. Remuneration committee. 4. Finance committee. Optional but common. 33. Powers of board. 1. Powers under Sec 179 include: approve financial statements, dividend declaration, issue shares and debentures, borrow money, approve related party transactions. 34. Powers to be exercised in board meeting. 1. Sec 179. Certain powers cannot be exercised without board approval in meeting. 2. Requires quorum and resolution. 35. Delegation of powers of board. 1. Sec 179. 3. Board may delegate powers to Committee of Directors, Managing Director, KMPs. 2. Delegation cannot include powers requiring member approval. 36. Restriction on powers of board. 1. Cannot alter articles, approve financial statements, approve dividends, requires members to core powers reserved for board or shareholders. 37. Contributions to charitable funds. 1. Sec 181. Company can donate as less than or equal to 5% of average net profits. 2. Approval required via board resolution. 38. Intercorporate loans, investments, guarantees, and security. 1. Sec 186. Company can lend invest up to 60% of net worth or 100% of free reserves. 2. Exceeding limits equals require members' approval by special resolution. 39. Loan and investment by companies. 1. Must be in ordinary course of business. 2. Approval. Board plus members if exceeding limits. 40. Company to make investments through not more than 2 layers. 1. Sec 186. 1. Investment via subsidiaries limited to 2 layers. 2. Prevents complex pyramids of investment. 41. Procedures involved in making loan, giving guarantee, and providing security. 1. Board resolution required. 2. RPT approval if applicable. 3. Disclosures in financials Sec 134. 42. Limits for loans, guarantees, security, and investment. 1. Up to 60% net worth, 100% free reserves. 2. Exceeding equals members special resolution. 43. Approval from members. 1. Sec 186. 3. Special resolution if exceeding prescribed limits. 2. Quorum and voting per Sec 100-2105. 44. Disclosure in financial statements. 1. Sec 134. 3. Details of loans, guarantees, security, investments, related party transactions. 2. Mandatory schedule disclosure. 45. Investments to be held in company's own name. 1. Sec 187. Company cannot hold investments in third-party name. 46. Related party transactions. 1. Sec 188. RPTs require board approval, audit committee review, member approval if material. 47. Information to the board for related party transactions. 1. Must disclose name, nature, value, terms of transaction. 2. Directors with interest cannot participate in vote. 48. Prior approval of the company by resolution. 1. RPT exceeding 10% of turnover or 100 crore rupees equals members' approval via ordinary or special resolution. 49. Related party not to vote on resolution. 1. Interested directors parties cannot vote on RPT approval. 50. Disclosure in board's report. 1. RPTs, loans, guarantees, investments must be disclosed. 2. Sec 134. 3. Financial transparency and compliance. Key case laws. 1. Tata Steel vs SEBI. Audit committee oversight of RPTs critical. 2. Assisi Bank vs SEBI. Related party transaction without board approval invalid. 3. Infosys Limited vs MCA. Risk management and CSR reporting compliance enforced. Exam tips. 1. Mandatory committees. Memorize composition, functions, penalties. 2. RPTs. Board, audit committee, members' approval, disclosure. 3. Loans, investments, limits, approval, disclosure. 4. CSR committee. Threshold companies and reporting. 5. Delegation versus restriction. Know which powers cannot be delegated. 6. Sample resolution often asked for board approvals or committee formation. Lesson 16. Meetings of board and its committees. Company law, India. 1. Meetings of board and its committees. 1. Board of directors meets to take collective decisions for company management. Sec 173. 2. Committees assist board in specialized functions. Audit, nomination and remuneration, CSR, risk, stakeholder relationship. 3. Board committee meetings must follow quorum, notice, agenda, and minutes rules. 4. Exam tip. Board and committee meetings are distinct. Quorum and notice rules differ slightly. 2. Frequency, convening and proceedings of the meetings of the board. 1. Board meeting at least 4 times a year. Interval is less than or equal to 120 days. 2. Convened by chairman or company secretary via written email notice. 3. Quorum. Min 1/3 of total directors or 2 directors, whichever is higher. Sec 174. 4. Proceedings documented in minutes within 30 days. 5. Penalty. Non-compliance. Company officers liable for 25,000 rupees fine Sec 174. 6. Case law. Tata Motors Limited vs MCA. Board resolution invalid if quorum not maintained. 3. Aspects to be considered while fixing the venue. 1. Venue should be within India. 2. Adequate facilities. Conference room, audio-visual setup. 3. Accessibility for all directors. 4. Venue reflected in notice of meeting. 5. Exam tip. International virtual meeting allowed only for non-core resolutions. 4. Board meeting through video conferencing. 1. Sec 173. Board may meet through VC or other audiovisual means. 2. Directors participating via VC are deemed present for quorum. 3. Suitable for listed and unlisted public companies. 4. Minutes must record participation mode. 5. Meetings of the board. 1. Required for approval of financial statements, dividend declaration, borrowings, intercorporate loans and investments. Related party transactions. 2. Chairperson presides over meetings. 3. Quorum and notice must be strictly followed. 6. Meetings of committees. 1. Each committee audit, NRC, CSR, etc. may meet independently. 2. Quorum typically 2 members or 1-3, as per Sec 177,178. 3. Minutes maintained separately. 7. Preparation of notices for meetings of board committees. 1. Notice minimum 7 days before meeting Sec 173. 2. Must include date, time, venue, agenda, explanatory notes. 3. Mode, hand delivery, post, email, electronic platform. 4. Shorter notice allowed with consent of all directors. 8. Agenda management. 1. Prepare detailed agenda with supporting documents. 2. Prioritize important items requiring board approval. 3. Exam tip. Agenda preparation is key. Audit, RPT, loans are priority items. 9. Sample of important agenda items for board meeting. 1. Approval of financial statements and statutory filings. 2. Declaration of dividends. 3. Appointment removal of KMP or directors. 4. Approval of intercorporate loans, guarantees, investments. 5. Review of risk management and CSR reports. 10. Meeting management. 1. Convened by chairman or company secretary. 2. Notices sent with agenda and explanatory notes. 3. Attendance recorded. Quorum verified. 4. Minutes signed by chairman of meeting. 11. Convening a meeting. 1. Board meeting notice minimum 7 days Sec 173. 2. Agenda must be clear and circulated. 3. Shorter notice allowed with consent of all directors. 4. Minutes prepared within 30 days of meeting. 12. Meetings of committees. 1. Committee meetings follow board delegated powers. 2. Quorum. 2 members are as per committee rules. 3. Minutes maintained and reported to board in next meeting. 13. Attendance registers. 1. Maintain register of attendance for directors and committee members. 2. Required for audit and compliance purposes. 3. Helps verify quorum and participation. 14. Leave of absence. 1. Directors may seek leave in writing email. 2. Recorded in minutes of meeting. 3. Non-attendance without leave does not affect quorum if minimum directors present. 15. Chairman of the meeting of the board committee. 1. Presides over meeting. 2. Decides agenda flow, discussions, voting. 3. Chairman's signature mandatory on minutes. 16. Minutes. 1. Must be prepared within 30 days Sec 118. 2. Signed by chairman of meeting. 3. Kept at registered office for inspection. 4. Includes date, time, venue, attendees, agenda, resolutions passed. 5. Penalty. Non-compliance. Company secretary fined 25,000 rupees. 17. Contents of minutes. 1. Date, time, venue. 2. Directors present absent. 3. Agenda items discussed. 4. Decisions resolutions passed. 5. Voting details if any. 6. Follow-up actions. 18. Types of resolutions. 1. Ordinary resolution. Simple majority 50% plus 1. 2. Special resolution. 75% majority. 3. Unanimous resolution. All directors agree. 4. Resolution by circulation. Board committee may approve without physical meeting Sec 175. 19. Resolution by circulation. 1. For urgent matters cannot wait for next meeting. 2. Requires consent of majority of directors. 3. Cannot be used for matters requiring member approval Sec 179. 20. Passing of resolution by circulation. 1. Draft resolution circulated via email post. 2. Signed resolved by directors and recorded in minutes. 3. Exam tip. RPT. Borrowings cannot be passed by circulation if member approval required. 21. Meeting of independent directors. 1. Sec 149(8). IDs must meet at least once a year without executive directors. 2. Discuss performance evaluation, risk, ethics, conflict of interest. 3. Minutes maintained and reported to board. 22. Duties of company secretary before, during, and after board committee meetings. Before meeting. Draft notice and agenda, circulate, confirm quorum. During meeting. Record minutes, ensure voting and procedures. After meeting. File resolutions forms with ROCDIR 12, MGT 7 if applicable. 23. Virtual board meetings. 1. Allowed under Sec 173. 2. 2. VC other audiovisual means acceptable. 3. Must ensure security, authentication, participation verification. 4. Minutes record participation mode. 24. Venue of the virtual meeting. 1. Must be within India. 2. Technical facilities for smooth interaction and voting. 3. Chairman and Secretary ensure quorum and participation. 25. Secretarial Standards 1. Secretarial Standard on Meetings of the Board of Directors. 1. Issued by ICSI. 2. Covers notice, agenda, quorum, minutes, voting. 3. Compliance ensures legal and procedural validity. 26. Specimen notice and minutes. Sample notice of board meeting. Greater than notice is hereby given that the Board of Directors will meet on date at venue to consider the following agenda. Greater than 1. Approval of financial statements greater than 2. Dividend declaration greater than 3. Appointment of KMP greater than. Kindly make it convenient to attend. Sample minutes of board meeting. Greater than the board met on date, quorum present, chaired by chairman. Resolved to approve financial statements, declare dividend, and appoint Mr. X as CFO. Meeting concluded at time. Minutes signed by chairman. Key case laws. 1. Tata Motors Limited vs MCA. Board resolution invalid if quorum not maintained. 2. Assisi Bank vs SEBI. Unauthorized RPT without board resolution held invalid. 3. Infosys Limited vs MCA. Minutes and proper notice essential for compliance. Exam tips. 1. Board meeting frequency, quorum, notice period. Memorize 4 meetings, 120 days, 7 days notice. 2. VC virtual meetings are valid if quorum maintained. 3. Minutes preparation and filing is mandatory. 4. Resolution types. Ordinary, special, unanimous, by circulation. 5. Independent directors meeting once a year. Key point. 6. Company secretary's role before, during, after meetings often tested. 7. Sample notices minutes may be asked in practical questions. Lesson 17. Corporate Social Responsibility CSR. Concepts. 1. Meaning of corporate social responsibility. 1. CSR is a company's commitment to contribute to societal development while pursuing business objectives. 2. Focus on sustainable development, ethical practices, and stakeholder welfare. 3. Voluntary Before Companies Act, 2013. Now mandatory for eligible companies. 4. Key principles. Transparency, accountability, sustainability. 2. CSR under the Companies Act, 2013. 1. Sec 135. Applicable to companies meeting any of the following thresholds. Net worth is greater than or equal to 500 crore rupees. Turnover is greater than or equal to 1000 crore rupees. Net profit is greater than or equal to 5 crore rupees 2. Mandatory CSR expenditure equals 2% of average net profits of preceding 3 years. 3. Penalty for non-compliance. Company. Fine 50,000 rupees. Officers. Fine 25,000 rupees 4. Case law. MCA vs Techno Corp Limited. Non-spending of CSR fund penalized. Statutory compliance is binding. 3. CSR committee. 1. Required for companies above thresholds. 2. Composition. Min 3 directors. At least 1 independent director listed companies 3. Appointed by board. Responsible for oversight of CSR activities. 4. The functions of CSR committee. 1. Formulate CSR policy. 2. Recommend annual action plan and budget. 3. Monitor CSR program implementation. 4. Ensure statutory compliance and reporting. 5. Meeting of CSR committee. 1. At least 1. 2 meetings per year recommended. 2. Notice sent 7 days prior. 3. Minutes recorded and reported to Board of Directors. 6. Functions and responsibilities of the Board. 1. Approve CSR policy and annual action plan. 2. Ensure CSR expenditure of 2% of net profits. 3. Monitor CSR projects and agencies. 4. Report in Board's report Sec 134. 7. CSR implementation. 1. Implement directly or through registered trust or society. Section 8 Company 2. Must be aligned with CSR activities listed under Schedule 7. 3. Expenditure to be spent within the financial year. Carry forward allowed only for ongoing projects. 8. Identifying appropriate implementing agency. 1. Agencies must be registered under Sec 8 companies, societies, or trusts. 2. Conduct due diligence. Track record, experience, statutory compliance. 3. Board CSR committee approve selection. 9. CSR policy and annual action plan. 1. CSR policy. Approved by board based on CSR committee recommendations. 2. Must include activities undertaken, implementation method, budget and timelines, monitoring mechanism. 3. Annual action plan. Detailed year-wise activities and cost. 10. Annual action plan. 1. Submitted to board for approval. 2. Activities must comply with Schedule 7 and MCA clarifications. 3. Board ensures execution and reporting. 11. CSR activities. 1. Promoting education, gender equality, healthcare, environmental sustainability. 2. Reducing inequalities in rural development. 3. Skill development, social business projects. 4. Contributions to Prime Minister Relief Fund or similar notified funds. 12. MCA clarifications. 1. CSR funds cannot be used for business promotion or political contributions. 2. Surplus from CSR activities cannot form part of business profit. 3. Expenditure on normal business operations is not CSR. 13. Computation of net profit. 1. Sec 198 and Sec 135 read with Rule 2. Net profit equals profit before tax excluding items specified under Sec 198 1. 2. Used to calculate 2% CSR expenditure. 3. Adjustments for extraordinary income expenses allowed. 14. CSR expenditure. 1. Minimum 2% of average net profits for preceding 3 years. 2. Must be spent in the financial year. 3. Excess can be carried forward for upcoming years for ongoing projects. 4. Penalty for default. Company fined 50,000 rupees. Officers fined 25,000 rupees. 15. Ongoing project. 1. Project exceeding 1 financial year is considered ongoing. 2. Amount spent in previous year can be adjusted in current year. 3. Must be disclosed in board report and CSR report. 16. CSR monitoring. 1. CSR committee and board monitor execution. 2. Ensure timely implementation, proper utilization and impact assessment. 3. Independent audit if required for projects greater than 1 crore rupees. 17. CSR reporting. 1. Sec 134-3. Board must report in annual report. CSR policy. Projects undertaken. Amount spent. Reasons for unspent amount, if any. 2. MCAE CSR reporting via CSR portal mandatory. 18. Impact assessment for big CSR projects. 1. Mandatory if project greater than 1 crore rupees or as per MCA notification. 2. Assess effectiveness, societal impact, sustainability. 3. Reports maintained by CSR committee and disclosed in board report. 19. Non-applicability of CSR provisions on specified companies. 1. Sec 135-5. Small companies or those not meeting thresholds are exempt. 2. Still may undertake CSR voluntarily. 20. CSR portal. 1. MCA maintains online CSR portal for reporting and filing. 2. Annual reports, project expenditure, and progress uploaded. 3. Ensures transparency and compliance. 21. Other aspects to keep in mind while undertaking CSR. 1. Ethical alignment with business objectives. 2. Avoid duplication with government schemes. 3. Ensure proper documentation, auditing, impact assessment. 4. Collaboration with experienced agencies. 22. Business responsibility reports by listed companies. 1. SEBI requires BER under Lauder 2015. 2. Covers ESG initiatives including CSR. 3. Disclosed in annual reports or websites. 23. Guidelines on CSR and sustainability for CPSEs. 1. CPSEs guided by DPE guidelines. 2. Mandatory CSR budget and project implementation. 3. Monitor outcomes and submit annual CSR reports to government. 24. Social stock exchange. 1. Proposed platform for listing social enterprises. 2. Helps mobilize CSR funds through listed entities. 3. Facilitates transparency, reporting, and impact measurement. 25. Specimen resolutions. Sample board resolution for CSR committee formation. Greater than resolved that the board hereby constitutes a CSR committee comprising of director names, in compliance with Sec 135 of Companies Act, 2013, to oversee CSR activities, recommend policy, and monitor execution of projects. Committee to report quarterly to board. Sample CSR policy approval resolution. Greater than resolved that the board approves the CSR policy prepared by CSR committee, as per Schedule 7 of Companies Act, 2013, and authorizes spending 2% of average net profits for FY 2025-26 on identified CSR activities. Key case laws. 1. MCA vs. Techno Corp Limited. Non-spending of CSR fund penalized. 2. Infosys Limited vs. MCA. CSR reporting and board responsibility reinforced. 3. Tata Consultancy Services Limited vs. MCA. Impact assessment mandatory for large projects greater than 1 crore rupees. Exam tips. 1. Sec 135 and Schedule 7. Memorize thresholds, 2% expenditure, committee composition. 2. CSR committee. Functions, meeting frequency, reporting. Often asked. 3. Net profit computation and expenditure rules. Common question. 4. Ongoing projects, impact assessment, MCA clarifications. Key points. 5. Specimen resolutions are frequently asked in practical exams. 6. Business responsibility reports and social stock exchange. Newer topics, check current MCA notifications. Lesson 18. Annual report. Concepts. 1. Introduction. 1. Annual report equals comprehensive statement of financial performance, management commentary, and statutory disclosures. 2. Serves as a key communication tool between company and shareholders. 3. Ensures transparency, accountability, and compliance with Companies Act 2013 and SEBI regulations. 4. Includes financial statements, board's report, CSR report, audit report, director's responsibility statement. 5. Exam tip. Remember board report plus annual return plus financial statement form the core of annual filing. 2. Disclosures by board. 1. Sec 134. Board to provide detailed disclosures in report. 2. Disclose related party transactions, loans and guarantees, CSR expenditure, key managerial personnel, directors, remuneration. 3. Penalty. Non-disclosure. 100,000 rupees fine on company and officers. 4. Case law. Infosys Limited vs. MCA. Disclosures must reflect true and fair view, incomplete info can attract penal action. 3. Annual report. 1. Covers financial statements, auditor's report, board report, CSR report, management discussion. 2. Mandatory for all companies except OPC small company abridged reporting allowed. 3. Filed with Registrar of Companies ROC along with Form AOC 4. 4. Must reach shareholders 21 days before AGM. 5. Penalty. Non-filing. 100,000 rupees for company and officers. 4. Statement of deviation S or variation S. 1. Sec 134 3 CA. Disclose any deviation from object's financial projections in prospectus annual report. 2. Explains shortfall in utilizing funds raised via public offer or borrowings. 3. Mandatory for listed companies. Filed in board's report. 4. Exam tip. Always link deviation to fund utilization and investor protection. 5. Board's report. 1. Sec 134. Board report is management narrative of company performance. 2. Must include financial performance summary, directors' responsibility statement, key changes in company structure KMP, CSR activities and expenditure, risk management and internal controls, material events after year-end. 3. Approval by board before signing, filed with ROC. 4. Penalty. Failure attracts 100,000 rupees fine. 5. Case law. Tata Steel Ltd versus MCA. Board report incomplete disclosure of loans equals penalized. 6. Secretarial Standard on Report of the Board of Directors SS4. 1. Issued by ICSI. Provides format and content guidelines for board's report. 2. Ensures minimum mandatory disclosures, standardized presentation, transparency in remuneration, loans, CSR, and RPT. 3. Complying with SS4 protects officers from penalty. 7. Disclosures under Section 134(3). 1. Financial highlights and performance summary. 2. Details of directors and KMP. Board meetings held. Dividend declarations. Material changes, loans, guarantees, investments. Corporate governance report if applicable. 3. CSR activities and expenditure. 4. Internal financial control and risk management. 8. Abridged board report for OPC and small company. 1. OPC and small companies can file simplified report Sec 92 and 134. 2. Mandatory disclosures. Board composition. Profit loss statement. Dividend declaration. Key changes in management. 3. Exempted from full reporting. CSR, directors' remuneration disclosure if small company. 4. Exam tip. Remember full report for medium and large companies, abridged for OPC small. 9. Approval of the board's report. 1. Board must approve before signing by chairperson director. 2. Signed by chairperson. All directors or at least one director. Company secretary if applicable. 3. Must be filed with Form AOC4 with ROC within 30 days of AGM. 10. Right of members to receive copies of financial statements, board's report. 1. Members entitled to receive copies at least 21 days before AGM. 2. Electronic mode allowed with consent Sec 136. 3. Penalty. Failure to provide 100,000 rupees fine on company and officers. 11. Filing of the board's report. 1. Form AOC4 filed within 30 days of AGM with ROC. 2. Includes financial statements, board's report, auditor's report. 3. Late filing. Penalties per Sec 134 and 447. 12. Procedure for preparation of board's report. 1. CSR and RPT data compilation. 2. Drafting financial highlights and disclosures. 3. Approval by board. 4. Signed by chairman directors. 5. Filing with ROC via Form AOC 6. Attached with annual report to shareholders. 13. Annual return. 1. Sec 92. Snapshot of company structure, shareholding, directors, KMP, debt and charges. 2. Filed with ROC via Form MGT 7. 3. Covers financial year. 4. Signatures by director and CS mandatory. 14. Objective of filing annual return. 1. Transparency of ownership and control. 2. Shareholders and regulators can verify compliance and governance. 3. Supports investor protection and statutory monitoring. 15. Signing of annual return. 1. Directors and company secretary if appointed must sign. 2. Certifies accuracy and compliance with Sec 92. 16. Certification of annual return. 1. Practicing company secretary PCs may certify truthfulness of filing. 2. Ensures reliability and legal compliance. 17. Filing of annual return with registrar. 1. MGT 7 filed within 60 days of AGM. 2. Penalty for default. 50,000 rupees company and officers. 3. Late filing may attract additional daily fines. 18. Active company tagging identities and verification active. 1. MCA initiative. Tag companies as active if KYC compliance done. 2. Helps ROC monitor active versus dormant companies. 3. Non-compliant companies may be deactivated, affecting filings and legal rights. 19. Specimen resolution formats. Sample resolution for approval of board's report. Greater than resolved that the board of directors of company name hereby approves the board's report for the financial year ended date, including financial statements, CSR report, RPT disclosures, and other statutory disclosures, and authorizes filing with the registrar of companies. Sample annual return approval. Greater than resolved that the annual return for the financial year ending date, prepared in Form MGT 7, be and is hereby approved and signed by the director company secretary and filed with ROC. Key case laws. 1. Infosys Ltd versus MCA. Board report must present true and fair view, incomplete disclosure attracts penalty. 2. Tata Steel Ltd versus MCA. Non-filing of annual return board report penalized. 3. Assisi Bank versus SEBI MCA. Material deviations in annual report must be disclosed. Exam tips. 1. Memorize sections 134 and 92. Board report and annual return. 2. Timeline. Board report. 30 days post-AGM. Annual return. 60 days post-AGM. 3. OPC small company can submit a bridge board report. 4. Disclosures. CSR, RPT, loans, KMP remuneration. High priority. 5. Active tagging. Recent MCA initiative may appear in practical scenario questions. 6. Specimen resolutions are often asked in practical problem-based questions. Absolutely. Lesson 19. Key managerial personnel KMPs and their remuneration. Company law, India, is very exam-oriented. Here's a detailed, subheading-wise guide, including timelines, compliance, powers, penalties, case laws, specimen resolutions, and exam tips. Lesson 19. Key managerial personnel KMPs and their remuneration. 1. Various KMP positions and definition under Companies Act, 2013. 1. KMP equals senior management officers who have key decision-making powers. 2. Defined under Sec. 251 of Companies Act, 2013. 3. Positions include Managing Director MD, Whole-Time Director WTD, Manager, Company Secretary CS, Chief Executive Officer CEO, Chief Financial Officer CFO. 4. Listed companies must have all KMPs, unlisted companies, as per thresholds. 5. Role, ensure compliance, reporting, strategy, and governance. 2. Appointment of key managerial personnel. 1. MD, WTD, Manager, appointed by board with approval of shareholders if required. 2. CEO, CFO, CS, appointed by board. 3. Term, typically 5 years max renewable. 4. Filing with ROC via Form DIR-12 mandatory within 30 days. 5. Penalty for non-compliance, 100,000 rupees company and officers. 6. Case law, Infosys Limited versus MCA. Improper appointment of KMP can be penalized. 3. No person shall act as chairman and MD CFO at same time. 1. Sec. 203 read with Sec. 218 and 219. 2. Ensures separation of powers and prevents conflict of interest. 3. Violation attracts fine, 100,000 rupees. 4. Manner of appointment of KMP. 1. Resolution at board meeting. 2. Shareholder approval if appointment exceeds remuneration limit. 3. Filing with ROC in Form DIR-12. 4. Appointment letter to KMP must contain role, powers, remuneration, term. 5. Vacancy of KMP. 1. Sec. 203. Company must fill vacancy within 6 months. 2. Non-compliance. Penalty 100,000 rupees. 6. Intimations regarding appointment of KMP. 1. Sec. 203 and Rule 8. File DIR-12 with ROC within 30 days. 2. Notify stock exchanges for listed companies. 7. Role of KMP. 1. Strategic and operational management. 2. Ensuring statutory compliance. 3. Board reporting and corporate governance. 4. Liaison between management, regulators, and shareholders. 8. Appointment of MD, WTD, or manager. 1. Board approval and shareholders' approval if required. 2. Term not exceeding 5 years. 3. Maximum 2 concurrent directorships in other public companies. Sec. 167. 9. Appointment with approval of central government. 1. Required in case of public company greater than prescribed limit and no profits. Remuneration exceeds limits of Sec. 197 Schedule 5-2. Application via Form MR1 with CG. 3. Public notice required 14 days prior to filing. 10. Powers, duties, and responsibilities of MD. 1. Manage day-to-day operations. 2. Sign contracts, financial statements, agreements. 3. Ensure compliance with law. 4. Accountable to board and shareholders. 5. Liable under Sec. 166 duties and 447 penalties for default. 11. CEO and CFO. 1. CEO. Operational head, implementation of strategy. 2. CFO. Financial planning, reporting, compliance, treasury functions. 3. Both report to board and must be KMP in all listed companies. 12. Appointment of company secretary. 1. Sec. 203. Mandatory for listed companies. Public companies greater than 10 crore rupees paid up capital. 2. Appointed by board. 3. File DIR-12 with ROC within 30 days. 13. Areas where CS renders services. 1. Corporate governance and compliance. 2. Board and shareholder meetings. 3. Statutory filings and regulatory liaison. 4. Corporate communications and public relations. 5. Hour and IT oversight as per organization needs. 14. Role of company secretary. 1. KMP for listed companies. 2. Ensures compliance with Companies Act, SEBI, secretarial standards. 3. Reports to MD, CEO and board. 4. Maintains statutory registers and records. 15. Legal advisor for business. 1. Provides legal guidance on contracts, mergers, litigation, compliances. 2. Ensures board and KMP act within statutory limits. 16. Procedure for appointment of whole-time CS. 1. Board resolution appointing CS. 2. Filing DIR-12 with ROC within 30 days. 3. Approval from board and remuneration committee if listed. 17. Duties of a company secretary. 1. Ensures statutory compliance. 2. Prepares board and shareholder meeting notices. 3. Maintains registers, returns, minutes. 4. Advises board on governance, ethics, and legal matters. 18. Removal of company secretary. 1. By board resolution. 2. Notice period as per employment contract. 3. File Form DIR-12 with ROC. 19. Officer who is in default. 1. KMP may be liable under Sec. 166, 447, 450, 454. 2. Penalty. Fines and imprisonment depending on nature of default. 20. Managerial remuneration. 1. Sec 197. Limits for MDWTD manager. Is less than or equal to 11% of net profit for all directors together. 2. Shareholder approval required if exceeds limits. 3. Remuneration includes salary, perquisites, commission. 21. Overall maximum managerial remuneration. 1. Sec 197 and Schedule 5. 5% of net profits to MDWTD manager individually. 10% to whole board including MDWTD manager. 2. Exceeding limits requires shareholder approval and CG approval if needed. 22. Remuneration in case of absence or inadequacy of profits. 1. Schedule 5, Part 2. Allows payment of remuneration even if no profits. 2. Approval required from board, shareholders and CG depending on thresholds. 3. Max limits prescribed in Schedule 5. 23. Determining remuneration of director, MD, WTD, manager. 1. Remuneration based on profit of company, industry standards, responsibilities and risk involved. 2. Requires board recommendation and shareholder approval. 24. Recovery of managerial remuneration. 1. Excess remuneration not in compliance with Sec 197 Schedule 5 can be recovered by company. 2. Non-compliance liable under Sec 450 and 454. 25. Additional compliances for payment of managerial remuneration in case of no profits, inadequate profits. 1. File application to CG for approval if company has inadequate profits, remuneration exceeding Sec 197 limits. 2. Publish general notice 14 days prior. 3. Maintain board resolution and approval records. 26. Compensation for loss of office of MD, WTD, or manager. 1. Payable under employment contract in Sec 202. 2. Can include notice period pay, severance or gratuity, unpaid commission bonus. 3. Requires board approval. 27. Specimen resolution. Sample board resolution for appointment of MD manager. Greater than resolved that name be and is hereby appointed as managing director of the company for a period of 5 years with effect from date, on the terms and conditions including remuneration as approved by the board, in accordance with Section 196, 197, and Schedule 5 of the Companies Act, 2013, and the applicable rules. Sample board resolution for remuneration approval no profits case. Greater than resolved that pursuant to Schedule 5 of the Companies Act, 2013, name be paid remuneration of rupee amount per annum as managing director despite inadequacy of profits for the financial year FY, subject to central government approval if required. Key case laws. 1. Infosys Limited vs MCA. Improper appointment remuneration of KMP is penalizable. 2. Tata Motors Limited vs MCA. Remuneration exceeding statutory limits without CG approval is invalid. 3. Assisi Bank Limited vs MCA. Recovery of excess remuneration legally enforceable. Exam tips. 1. Memorize Sec 196, 197, 203 and Schedule 5. Appointment and remuneration limits. 2. KMP positions and dual roles. Frequently asked. 3. Appointment, filing DIR 12 timelines. 30 days. 4. Remuneration in case of inadequate no profits. Approval of board, shareholders and CG required. 5. Specimen resolutions. Very important for practical problem questions. 6. Recovery of excess remuneration and officer in default. Link to penalties under Sec 450,454.